The testimony begins without spectacle. A federal courtroom, fluorescent lights humming softly, a court reporter adjusting her machine, pages stacked neatly on a polished wooden table, names spoken slowly for the official record, and under oath, every word carries weight. According to publicly released court transcripts and sworn depositions, witnesses described schedules, flight paths, introductions, financial arrangements, staffing structures, movements that on the surface appeared administrative, routine, almost forgettable, travel between properties, meetings framed as professional, social gatherings documented in calendars. But this is where it becomes unsettling, because when those ordinary details are placed side by side under oath, patterns begin to align, dates repeat, locations resurface. The same address is mentioned across different testimonies. A townhouse in Manhattan, a residence in Palm Beach, a ranch in New Mexico, a private island in the U.S. Virgin Islands, each property referenced in sworn statements, each location tied to structured routines described by employees. According to court filings, staff members testified about visitor logs, security protocols, scheduled appointments, instructions on how guests were received, who escorted them, which rooms were accessible, and who had authority inside the household hierarchy. The language in transcripts is controlled, restrained, technical, but the repetition forms something larger than a single moment. And this is where the documents get interesting, because depositions reference non-disclosure agreements, confidential settlements, sealed motions. Public records indicate that certain civil cases were resolved before trial. Some files remained sealed for years before partial unsealing by court order. Mentioned in documents does not imply wrongdoing, but the recurrence of legal shielding mechanisms appears consistently across filings. Under oath, pilots confirmed flight, manifests later entered into evidence, assistants acknowledged managing detailed calendars, property managers referenced surveillance systems and digital storage devices cataloged in inventory lists, computers, hard drives, external storage units, all documented through formal procedure. Nothing dramatic in tone, everything procedural in nature. But the real question is not who appeared on a single flight log. The real question is how repeated logistical patterns existed across years without broader institutional disruption. And this changes the scale of everything. Do you want to know the truth behind the Epstein case? The darkest, most shocking secrets that the powerful don't want you to know. Then you need to follow this channel right now. Click the subscribe button and turn on the notification bell, because what we're about to reveal will shake the very foundations of power. And you can't miss a single detail. Prepare yourself for a journey into the depths of depravity and corruption, and join us in this fight for justice. Subscribe now, because in sworn testimony, witnesses were asked precise questions. Who was present? When did they arrive? How long did they stay? What instructions were given? And the answers often followed the same formula, to the best of my recollection. As reflected in the records, I do not recall still. Within that restraint, consistency emerges. Public records show that in 2008, a non-prosecution agreement was executed in Florida limiting certain federal charges in exchange for negotiated terms. That agreement later became the subject of legal scrutiny and additional litigation. Under oath, prosecutors and defense attorneys debated jurisdiction, state authority versus federal authority, the scope of immunity provisions, and notification procedures, structural questions that shaped outcomes before public awareness caught up. And this is where the pattern shifts. Because the testimonies are not limited to individuals, they extend into institutional decision-making, who had authority to prosecute, who declined to pursue charges, what legal thresholds were applied, what disclosures were required. These questions appear repeatedly in hearings and filings. According to publicly available records, financial transactions were examined, settlement agreements referenced, trust structures outlined in civil complaints. Attorneys questioned the origin, timing, and purpose of certain transfers. Again, the language remains clinical, no emotional framing, only documented exchanges between counsel and witness, objection, sustained rephrase. The rhythm of the courtroom shapes what enters the record and what does not. And this is where it becomes more complicated, because many documents include redactions, black bars obscuring names, paragraphs sealed, exhibits referenced but not visible to the public, judges weighing privacy concerns against transparency. Mentioned in documents does not imply guilt. That principle anchors due process. Yet the density of association across transcripts creates public tension. Under oath, some witnesses described recruitment processes framed initially as employment opportunities, administrative roles, scheduling tasks. According to civil filings, several later stated that expectations changed. These statements were entered as allegations within formal legal boundaries. The transcripts do not dramatize, they document. And this changes the focus again, because what emerges is not a cinematic narrative, but a structural one. Repeated references to private meetings, controlled access, layered agreements, negotiated settlements, investigative pauses, reopened inquiries. Institutional discretion exercised at critical junctures. Public records show that renewed federal charges were filed in 2019. Affidavits described evidence seized pursuant to search warrants, inventory, and institutional failures documented in official reports. And this is where the discomfort deepens, because under oath, detention officials were questioned about compliance, oversight mechanisms, internal accountability. Again, the focus shifts from personality to process, from allegation to administrative breakdown, from individual action to systemic vulnerability. No formal charges were filed against many individuals mentioned in flight logs or address books. That fact remains critical. Your presence in a record does not establish misconduct. Mentioned in documents does not imply wrongdoing. The legal system requires more than association. Yet the breadth of reference across testimonies highlights scale. And what happened next raised even more questions. Congressional hearings were convened. Oversight committees requested additional disclosures. Reports were issued addressing prosecutorial decisions and detention oversight. Yet numerous documents remain sealed. And sealed records create a boundary between public knowledge and institutional memory, because testimony under oath reveals what can be admitted at a specific time based on available evidence and legal strategy. Attorneys narrow questions carefully. Witnesses respond within defined limits. Truth in court is filtered through admissibility standards. Procedural rules determine narrative shape. And this is where it becomes intellectually unsettling. The public often expects a single revelation, a definitive explanation, but what the testimonies provide instead are fragments, certified, transcribed, archived, fragments that map systems rather than deliver conclusions, descriptions of structured environments, acknowledgement of financial settlements, confirmation of travel patterns, recognition of negotiated agreements, references to prosecutorial discretion, statements about surveillance systems. Each element appears in record form, restrained, deliberate, measured, nothing theatrical, everything procedural. And yet procedure is power, because systems determine outcomes long before verdicts, who investigates, who negotiates, who seals, who unseals, who exercises discretion. These are structural labors embedded within institutional design. The testimonies taken collectively do not resolve every question. They expose architecture, a framework of privilege, confidentiality agreements, jurisdictional boundaries, negotiated immunity, institutional delay, strong and layered accountability. No single transcript explains the entirety, but together they trace contours of influence intersecting with enforcement. Under oath, individuals answer questions, but institutions answer through policy, through redaction, through procedural timing. And this is where the weight settles. Not on a headline, not on speculation, but on structure. The record remains public, accessible, incomplete. What was said under oath is documented. What remains sealed is procedural. And between those two realities lies the ongoing tension surrounding transparency and accountability. The documents do not move in straight lines. They expand outward, layer by layer, filing by filing, year by year, and this is where it becomes more complex. Because once testimony is given under oath, it does not simply sit in isolation. It connects to other proceedings, other jurisdictions, other civil complaints, according to publicly available court records. Civil litigation continued even after criminal proceedings shifted direction. Survivors filed lawsuits, attorneys submitted motions to unseal records, judges weighed competing interests between privacy and transparency. And this is where the scale quietly widens. Depositions taken in one case were later referenced in another. Sworn statements cross-cited across jurisdictions, language repeated, patterns revisited, allegations referenced in filings remained within procedural boundaries. Carefully worded, constrained by evidentiary standards, mentioned in documents does not imply wrongdoing. Yet the density of cross-reference becomes difficult to ignore. Public filings indicate that financial institutions were drawn into review processes. Compliance departments examined prior transactions. Internal reports were requested. Attorneys questioned whether reporting obligations had been triggered under federal law. These inquiries were not theatrical. They were administrative. They conducted through document requests, subpoenas, regulatory correspondence. But this is where the documents get interesting. because financial architecture often reveals operational architecture. According to court records, multiple entities were used to hold assets, trusts were established, foundations created, property transfers executed. Through structured agreements, attorneys questioned timing, purpose, and beneficiaries. Again, the language remains restrained. Yet the complexity suggests intentional design, and this shifts the focus from events to infrastructure. Because infrastructure sustains continuity, properties require maintenance, travel requires coordination, accounts require management, legal strategies require foresight. Under oath, former employees described chains of instruction, who approved payments, who authorized schedules, who mediated disputes. These are operational questions, not headline questions. What becomes visible is not chaos, but continuity. And continuity raises structural questions. How did oversight mechanisms respond? According to public records, certain regulatory reviews occurred after renewed federal charges were filed in 2019. Compliance examinations were referenced. Internal communications entered into evidence. Again, no definitive conclusions about every participant, but documented acknowledgement that institutional review processes were activated. And this is where it becomes unsettling again, because a review often follows exposure, not prevention. Court filings show that investigative momentum accelerated at specific moments. Search warrants were executed, affidavits outlined probable cause under federal standards, inventories were cataloged in formal language, each item described precisely, each digital device recorded. Yet what becomes public is only what survives evidentiary thresholds. And this creates a second layer of tension between what is known privately within institutions and what becomes admissible publicly in court. Under oath, witnesses were sometimes confronted with emails and address books that had been entered into evidence. Some contacts were explained as social or professional networking. Others disputed entirely. Defense counsel emphasized the absence of charges against many referenced individuals. That absence remains a critical legal fact. Mentioned in documents does not imply guilt. Still, the repetition of high-level proximity appears consistently in filings, and this changes the conversation. Because proximity to influence intersects with prosecutorial discretion. According to publicly available records, earlier charging decisions were later reviewed internally by the Department of Justice. Official statements acknowledged that aspects of the 2008 agreement were controversial. Congressional inquiries examined how that agreement had been structured. The questions were procedural. Who negotiated the terms? Who approved them? Who was notified? Who was not? And this is where institutional accountability enters the frame, not as accusation, but as examination. Public hearings included testimony from federal officials. Internal communications were requested. Policy reforms were discussed. Again, the language remained careful, measured, structured around statutory interpretation and departmental guidelines. No sweeping declarations, only incremental clarification. But the disturbing part is not a single decision. It is the cumulative pattern of discretion across years, across offices, across administrations. Because discretion shapes enforcement long before the public becomes aware of any case. Under oath, officials explained resource constraints, evidentiary challenges, jurisdictional complexities. These explanations exist in the record, yet they also reveal how flexible thresholds can become when cases involve high-profile defendants. And this is where the discomfort deepens, because systems are designed to operate impartially, yet they are executed by individuals making judgment calls within defined boundaries. Those boundaries are often technical, sometimes negotiable, always consequential. Public filings also reveal that civil litigation exposed additional layers of alleged misconduct. Survivors' attorneys argued for broader discovery. Defense counsel sought protective orders. Judges ruled on motions to compel, motions to dismiss, motions to seal. The procedural battle unfolded in hundreds of pages of legal argument, each page precise, each citation deliberate. And this is where it becomes clear that litigation is not just about outcome, it is about process, about what is allowed into the record and what remains excluded, about what is sealed and what is unsealed, about which narratives gain documentary footing. Because once something enters sworn testimony, it acquires permanence. It becomes part of institutional memory, even if it does not result in conviction. And this changes how these testimonies should be read, not as isolated confessions or denials, but as structural blueprints, mapping how influence, wealth, legal negotiation, and institutional discretion intersect. In 2019, after renewed federal charges, bail arguments were presented in court. Prosecutors argued flight risk, defense counsel proposed strict conditions, the judge weighed statutory factors. Detention was ordered, the language was procedural, referencing risk assessments, community safety, and statutory guidelines. Weeks later, the death in custody prompted additional institutional review. Inspector General reports later documented procedural lapses, staffing shortages, missed rounds, malfunctioning cameras, each failure itemized in official findings. Again, the focus shifted from individual narrative to systemic breakdown. And this is where the pattern becomes unmistakable. Oversight appears reactive, not preventative. Institutional reform discussions followed public scrutiny, not preceding it. Policy recommendations were issued, disciplinary measures discussed, yet the underlying question persists. What mechanisms ensure equal application of law across influence levels? According to court filings, several co-defendants were later charged and prosecuted in separate proceedings. Each case unfolded independently, evidence evaluated under standard burdens of proof. Plea agreements negotiated in some instances, trials conducted in others. The adversarial system functioned as designed, yet public perception remained shaped by earlier decisions. Because once confidence erodes, restoration requires more than procedure. It requires transparency. And transparency collides with privacy rights, with due process protections, with sealed agreements negotiated under lawful authority. This is not a simple narrative. It is a structural examination of how legal systems manage complexity when power, reputation, and criminal allegation intersect. Under oath, witnesses answered within limits. Attorneys guarded strategy. Judges enforced evidentiary rules. The system operated, yet the architecture revealed tension points where discretion and influence overlap. And this is where the documents leave us, with fragments that suggest design without offering total clarity. Because total clarity rarely exists within adversarial frameworks. Only incremental disclosure, only procedural advancement, only partial unsealing. Are you shocked by what we've uncovered so far? Well, that's just the tip of the iceberg. There's so much more to come. More powerful names, more sinister schemes, more silenced victims. If you want to be on the front lines of this investigation, you need to subscribe to this channel now. Leave your comment below and tell us what you think. Your voice is crucial in this fight. The more we unite, the stronger our call for accountability will be. So subscribe, comment, and share. The truth depends on it. The testimonies continue to shape civil litigation, public debate, and institutional reform discussions, not because they deliver spectacle, but because they reveal mechanisms, and mechanisms determine outcomes long before headlines appear. The question is no longer confined to individual conduct. It extends to institutional resilience, to prosecutorial independence, to regulatory vigilance, to detention oversight, to transparency standards. And this is where the scale becomes systemic, not personal. Because systems endure beyond any single case, and systems are what the record quietly exposes. By the time the later filings were unsealed, the narrative had already fractured into parallel tracks. Criminal proceedings, civil litigation, internal reviews, congressional inquiries, media analysis, each operating under different standards of proof, different disclosure rules, different timelines, and this is where the structure becomes visible in its full complexity. Because the Epstein testimonies did not exist in a vacuum, they were absorbed into institutions that respond according to mandate. Prosecutors evaluate admissible evidence. Judges interpret statutory boundaries. Defense attorneys protect constitutional rights. Regulatory agencies assess compliance obligations. Each actor confined to a defined role, and those roles determine what becomes actionable and what remains unresolved. According to publicly available court records, motions to unseal documents accelerated after renewed federal charges in 2019. Media organizations petitioned for transparency. Survivors' attorneys argued that public interest outweighed privacy concerns. Defense counsel countered with arguments grounded in due process and reputational harm. Judges issued carefully reasoned opinions, sometimes granting partial disclosure, sometimes maintaining redactions. And this is where it becomes intellectually heavier, because redaction is not merely concealment. It is a legal instrument designed to protect ongoing investigations, privacy rights, and procedural integrity. Yet to the public, blacked out pages feel like absence, unanswered questions suspended in ink. The unsealed materials revealed additional sworn statements, additional names referenced in address books, additional logistical details about property and travel mentioned in documents does not imply wrongdoing. That remains a foundational legal principle. Still, the accumulation of proximity within official filings deepened public scrutiny. And this changes the tone of inquiry from individual behavior to institutional response. because once patterns are identified, attention shifts toward oversight, according to congressional hearing transcripts. Lawmakers question Department of Justice officials about earlier prosecutorial decisions. Internal review findings were summarized, policy adjustments discussed, yet no single hearing offered definitive closure, only incremental clarification. The adversarial system functions through burden of proof, and burden of proof is high by design. Allegations referenced in filings must satisfy evidentiary thresholds before they translate into indictment. Indictment must withstand judicial scrutiny before it reaches trial. Trial must satisfy constitutional safeguards before it results in conviction. These layers are intentional. They protect the innocent as much as they constrain prosecution. But this is where the discomfort returns, because high thresholds can appear uneven when influence intersects with enforcement. Public records indicate that some civil claims were resolved through confidential settlements. Such agreements are lawful mechanisms within the legal system, yet they also limit public visibility into factual findings. Settlement is not admission, dismissal is not exoneration. The legal meaning of each action is precise, but public interpretation is often broader. And this is where perception and procedure diverge. Under oath, survivors described experiences within the confines of civil complaints. Defense counsel challenged credibility. Judges ruled on admissibility. Juries were impaneled in some cases. Plea agreements were negotiated in others. The process unfolded according to established rules. Yet each procedural turn reinforced the sense that the case extended beyond any single courtroom, because what the testimonies ultimately revealed was not only alleged conduct, but structural tolerance for ambiguity. Ambiguity in enforcement timing, ambiguity in regulatory reporting, ambiguity in institutional coordination. These ambiguities are not conspiratorial. They are bureaucratic, the product of compartmentalized authority and jurisdictional fragmentation. Yet when layered across years, they form visible gaps. And this is where the pattern stabilizes. Oversight mechanisms activated primarily after public exposure. Internal reviews followed media scrutiny. Detention reforms were proposed after documented lapses. Compliance examinations intensified after renewed federal action in reactive cycles rather than proactive barriers. Publicly released Inspector General reports documented staffing failures and procedural violations within the detention facility where Epstein died. Those findings were specific, itemized, administrative, no dramatic language, only documented non-compliance with established protocol. And again, the focus shifted from personality to system. Because systems are what persist, individuals enter and exit the narrative, but institutional frameworks remain. Court records also show that subsequent prosecutions against associated individuals proceeded independently, evidence evaluated under standard burdens, plea negotiations conducted within statutory guidelines, trials scheduled, appeals filed. The machinery of justice continued to operate even as public trust fluctuated. And this is where the final tension resides. Trust is not built solely on outcome. It is built on perceived consistency. The consistency in charging decisions, consistency in oversight, consistency in transparency. The Epstein testimonies taken together do not provide a singular revelation. They provide documentation of how complex cases interact with complex systems. Wealth intersects with law, reputation intersects with procedure, discretion intersects with accountability. Under oath, individuals answered questions, some invoked constitutional rights, some denied knowledge, some acknowledged association. Each answer entered into record, certified, archived. The record itself becomes the enduring artifact. But the record is incomplete by design, constrained by admissibility, limited by settlement, shaped by negotiation. Transparency expands only as far as legal boundaries permit, and those boundaries are negotiated in courtrooms, not headlines. And this is where the investigation truly concludes, not with certainty about every allegation, but with clarity about institutional architecture. A legal system balancing due process and public interest, a regulatory framework responding to exposure, a detention system reviewed after failure, a prosecutorial apparatus exercising discretion within defined limits. The testimonies illuminated these mechanisms not through dramatic confession, but through structured documentation. The cumulative effect is not spectacle. It is structural introspection. Because the real question is no longer confined to what was said under oath. It is how institutions interpret, act upon, and disclose what is said when influence, legality, and accountability intersect. What determines the threshold for decisive action, and how transparent should those determinations be in a system built on both openness and protection. You've made it this far. You've seen how deep the rabbit hole goes, how vast the webs of complicity are. Now you have a choice. You can turn your back and pretend none of this happened, or you can join us. Subscribe to this channel, hit the like button, leave your comment, and most importantly, share this video, because the only way to defeat the darkness is to bring it into the light. The more people see, the harder it will be for the predators to hide. Together we can build an unstoppable movement for justice, but it starts with you, with your voice, your dedication, your click on that subscribe button. Let's make this echo in the halls of power. Let's shake the foundations of the mighty. Let's show the entire world what truth can do. But only if you join us now. Subscribe, act, and let's change history together.